Many of us at one time or another have been to a party that got a bit out of hand. New Year's Eve 2002 at Adeel's Palace in Punchbowl in Sydney took it to the next level. The restaurant area had a dance floor. One woman on the dance floor said that another woman had jabbed her with the burning end of a cigarette. A melee developed involving dozens of people. During the fracas, Anthony Moubarak hit another man in the face, drawing blood. The injured man left and returned with a handgun. Antoine Bou Najem, a bystander, found himself staring down the barrel. He pleaded for mercy, but was shot in the leg anyway. The gunman then found Moubarak and shot him in the stomach. Both men sued the venue, arguing that the venue had failed in its duty of care to keep them safe while they were on the premises by not providing security guards in the restaurant area. They were successful at trial and were also successful in the Court of Appeal. The matter then made its way to the High Court. The High Court overturned the decisions below on the basis of causation. In other words, the High Court found that it could not be shown that the failure to provide the security guards caused the injuries to the two plaintiffs. In making this decision, the court focused on what is called the but-for test, asking whether the harm would not have been caused but for the alleged breach of the duty. They said this had not been established because there was no way to be certain that security guards could have stopped an irrational gunman. The court said, recognising that changing any of the circumstances in which the shootings occurred might have made a difference, does not prove factual causation. Providing security at the entrance of the restaurant might have delayed the gunman's entry. It might have meant that if Mr. Bou Najem was a random victim, as seems to be the case, someone else might have been shot and not him. But neither plaintiff proved factual causation by pointing to possibilities that might have eventuated if circumstances had been different. From this case, we confirm that in negligence law in Australia, causation is established using the but-for test, and that merely showing that the harm might not have occurred but for the breach is not enough.